Ladies and gentlemen, welcome to the People's Law School, the Alabama Trial Lawyers. The Alabama Association for Justice has been putting this program on for about 25 years, and for about 20 years we've been on TV. We reach about 2 million people, and I want you to know we bring to you the best lawyers in America. Sometimes we even bring you the best lawyers in the world, which is tonight we've got for you Ed Gentle. And by the way, Ed Gentle is a real treasure. Homegrown, born in Birmingham, Alabama, grew up here. He's just a little younger than I am, and I want you to know his educational path was just a little bit different than mine. He first of all went to Auburn, where he was the #1 student. He then went on to Miami, where he was the #1 student. Then he was selected to be a Rhodes Scholar, like President Clinton, you know, and he went over to Oxford, England, and got 2 law degrees. In fact, he has 3 law degrees, because he's got 2 from Oxford, England, and 1 from Alabama. Over the years, he has been in Birmingham and has done some extraordinary things. For example, we've all heard of the future Alabama Constitution that someday may be written because ours is the worst in America. Well, guess who has written the Constitution if we ever get a new one? He and 2 other fellows are in fact the ones who have written that Constitution that is being proposed if it can ever get past the politics of it. Just to let you know. He's also been the lawyer for the Alabama Senate, and now he represents all of these people, these huge class actions, these mass torts, that these cases where people get billions and billions and billions of dollars, and I say that, I'm not kidding, literally billions of dollars. You know who handles it? The most trusted person you can find, and the judges have selected. The federal courts and the state court judges, they all say, they don't all say, but a lot of them say Ed Gentle. And so Ed Gentle is the man who handles those billions and billions of dollars, and he's doing it today right now. I think you're doing one in Birmingham as well as, well, there's so many. On the CV that you have in front of you, you can see some of them. But the long and short of it is he's a trusted man, he's a brilliant man, and when I tell you he's a real treasure for us, the people of Alabama, to have, I want you to know he has done a lot for us, and I know he will continue to do, and I'm glad to call him my friend, Ed Gentle. Thank you so much for coming. Thank you, thank you.
What do you do with an introduction like that? My goodness. So anyway, I've come to talk with y'all tonight about another unresolved area of the law. Remember last year we talked about medical monitoring, the fact that a lot of times you have a toxin in your body, be it PCBs or lead, and you don't know what it's going to do over time. And so the classic model, like I think you just talked about a truck wreck, you have a wreck, you get a check. Who's that guy, Pittman, you know? But the problem is you really don't know how much you're going to be hurt over a long period of time. So remember, medical monitoring evolved. You'd be tested every couple of years for 30 years and see how hurt you are. But that body of law was still incomplete because when you find out you're hurt, you ought to get paid a check then, right? And maybe get more if you get sicker later. Well, right now in America, that remedy doesn't exist. It's being talked about. I've got a law review article that's going to come out in the West Virginia Law Review. And West Virginia, ironically, is a very progressive state despite its reputation. In 1968, they eliminated the death penalty, for example. Did you know that? And medical monitoring began in West Virginia, that very innovative remedy I've just described. So you never know about places or people. You need to hear them out and get to meet them. So what I'm going to talk about today is another problem in the law, and it's growing. And if you just turn to your materials, I'm going to give you a problem set, and I want to get your feedback because really we don't have the answers. We're still developing this body of law. So I administer settlements. I've got one in Jefferson County you might have heard about. There was an occupation tax that you'd pay out of your paycheck. It was found to be illegal, so Judge Raines in Fort Payne, he ordered that the people should get their money back. There's 350,000 people. That's a lot of people, right? There's $30 million. That's about $100 a head. The entities that know who to pay are the employers. So we asked the employers, give us the data so I can give the employees their refund, right? So we did that a while, and we got a lot of that done. Some employers told us to pound sand. So we asked the employees, if you want to file a claim, you can. And we had it in the newspapers, it was on the radio. And when the dust all settled, we're over here, we're talking about this in this handout, 85% of the people got their money, and that's a pretty high percent in class actions. You might hear that some 25% show up, some 50%. But of the $30 million, we had $2.5 million left. Okay, I can't find 15% of the people. I pay 85%. what should happen to the $2.5 million, which was paid by the defendant for its wrongdoing? Okay, what do you think? Where should it go? Should it go as a dividend to the people that showed up? At least it's going to them. But what if you overpay somebody? What if you pay him more than he's hurt? What about the defendant? I mean, if you're Jefferson County, you pay damage to a victim, right? You don't pay damage if they never collect it. Why shouldn't it go back to Jefferson County? Those are just a few ideas. Another idea would be you might just give it to the state of Alabama. They take good care of your money, right? That's called escheat. You've probably heard of that. And then a final solution people talk about is let's just give it to a charity. But the charity wasn't a victim, right? They weren't hurt. They have nothing to do with the case. I have a question back there.
General Victims Fund.
Well, there's all kinds of charities. In fact, charities develop if there's a big case in mind. And I'll talk about that. There's a Facebook case in here in which Facebook and the plaintiff lawyer invented a charity to get the money.
Victims Fund.
Yeah, there are. For example, for people that are the victims of crime, there are such funds. But you know, you might want to have a victims fund. Someone else might have a favorite hospital. I mean, how do you resolve that? And by the way, it's not our money, is it? It belongs to the people that were hurt. So does that make any sense to pay it to a charity just because you can't find the people that are hurt? That's the problem.
Give it to the court system.
Well, you might do that, but someone else might say, I'd like to have my park improved down the street. You know, so I'd put to you that there's not a good answer to this problem. And so you might ask, where did the problem come from? Well, what happened? In 1966, class actions changed. You probably know what a class action is. A handful of people bring a claim for everybody that's just like them, likewise situated, they call it. For example, in the Jefferson County case, we had 350,000 people who claimed that their occupation tax was illegal, had maybe a dozen people file for them. But all 350,000 people didn't have to show up. It's called a Book of the Month Club approach. That is, you're told about it, that you're a class member, they publish it in the paper or whatever. You can come in and say, I'm going to opt out. I don't want to be in the class. But if you don't opt out, then Book of the Month Club says you're in it, like it or not, by default. But what happens if you do that is we have no idea who you are. But before 1966, it was the reverse. To be in a class action, you had to sign up. So the defendant knew going in who the people are, we could measure how much they're hurt, and pay them, and there's no money left. But once you flipped it to a Book of the Month Club approach, we had this problem. We can't find everybody. And so that's what it cropped up. And so courts started, scratching their heads about this. And what they did is they looked into another body of law. There's something called cypre, which is a fancy term. It's French for nearly. You pay something as near as possible if the original purpose is gone. And the first case to have it was a case called Jackson v. Phillips. And a fellow in Boston bequeathed to some trustees some money to create a public sentiment to abolish slavery. Well, when the 13th Amendment came along, there was still money left. So what do you do? Well, the court looked at that and they said, well, let's help indigent blacks in Boston get educated. But that's not the purpose, right? But it's kind of like it. It's a near purpose. So the courts looked around and tried to figure out what to do with this surplus as it began to develop after 1966 when the Book of the Month Club came in with class actions. So Miller v. Steinbeck is the first case to look at this. It's a New York federal case. And in that case, they're the owners of 4 million shares in one company that merged into another. And the shareholders said that the merger was unfair. They didn't get enough money. But the 4 million people just got $4 million. You can't distribute $1 a person, right? It just didn't work. And so there it is. And so what happened, the court scratched its head, said it's not practical to pay it, right? So it just said, let's just give it to the retirement fund for that company. Well, some of the stockholders are employees, but some weren't. It's not a perfect solution, but it's a solution. And so that's where it began. But doesn't this sound kind of like we're acting like a legislature? I mean, doesn't the legislature pay your money out to whoever it wants and not a court? For a court to pay money, don't you need a plaintiff that's hurt and a defendant who pays? Isn't that what that truck wreck case is all about? Can you imagine you're the trucker, you give $1 million and it ends up in somebody's church? You'd be pissed off, wouldn't you? You'd want it back. So that's where this is going. And What's really kind of frightening to me, because law is to adjudicate claims between a victim and a defendant, right? And the court decides who's right, who's wrong, and if there's not a victim, the defendant wins. If there is, the defendant should pay. But the court should not take that money and pay it somewhere else, right? And there are some cases where all the money goes somewhere else, and I've got some examples in here. I've got this Vasquez case in California. It was a credit fraud case. And the money went to a charity that educates consumers on credit transactions. No money went to the claimants. If you were a claimant, would you be happy? Another case, there's a compact disc antitrust case in Maine about antitrust prices. And the settlement was paid to a school of arts. And so that's how this has kind of evolved. And so I wanted to quantify the problem. I'm kind of a math science guy. So if you look on the back of the handout, we've got a few figures. We have figure 1 that it shows how this problem has grown over the years. So you remember in 1966, the problem began because we had the Book of the Month Club class action. Before then, you didn't have the problem. You had a fixed group of plaintiffs, had the defendant. You figured out if he owed the money. If so, you just pay him, right? You didn't have to go find people. But what's happened now in this figure 1, this shows federal cases, in federal court. There's state courts and federal court that have a Cypre award. And you can see 1991 to 2000, there are 21. 2001 to 2008, there's 65, so it's tripled. And a lot of times, like the examples I gave you, none of the money gets to the claimants, and that's in figure 2. And we call those, fancy lawyer term, faux settlements or false settlements, because the money didn't get to the claimant, right? It went to a charity or some other purpose. And you can see here in this figure 2, the false settlements, if you want to call them that, are about a third of the settlements that occurred during this time frame, from 1991 to 2008. Before 2001, 11 out of 30 were false settlements, so to speak, because the claimants didn't get any money. After 2000, 24 of 65 were about a third. And so that's the problem I want to talk with you about tonight and see if you have any ideas, because I'm scratching my head too. And you'll see the Supreme Court has recently said in November, the U.S. Supreme Court, they've never addressed it yet. So this is a live issue. And Cypre monies go to good uses. We talked about a victims' compensation fund. There's legal defense funds. There's all kinds of good uses. But should we make that choice? Should we decide what to do with other people's money? Or shouldn't they get their money and do whatever they want to with it? I think that's the American way, right? And I just wanted to show you also the kind of money we're talking about is on figure 3. These federal settlements, these are some averages here. They average about $51 million. $51 million a class action settlement. That's some loot, isn't it? And $5.8 million on average, $5.8 million goes to Cypre. That is, it doesn't get to the claimants. It goes to a charity, picked by the court, picked by the lawyers. And so usually, on average, 70% of the money goes to the claimants and 30% goes to charities in a settlement. And this Florida Law Review article, a pretty famous article about this, said that there are 10 cases where Cypre awards were 75% or more of the total damage. So let's talk about these alternative solutions to this surplus idea. So let's go back to the claimant. We know, at least if you're a class member, you're a claimant, there's been a settlement, and the defendant may disagree that you're hurt, but he's paying money to you as if you're hurt, right? If you have a judgment, the court found you're hurt. So that sounds pretty legitimate, doesn't it? Shouldn't that person get the money? So a pretty famous writer, Adam Liptak, you might read him in the New York Times. He's always writing these legal articles. He had this article that came out about 10 years ago called Doling Out Other People's Money. And that's what he's talking about. So in that case, there was $6 million of unclaimed money in a settlement brought by fashion models. And the judge, I guess he decided, well, what do we do with this? And he talked to the lawyers, and he paid $500,000 of the surplus to a substance abuse program, $1 million for an eating disorder, and so on. And Adam Liptak says, well, why don't you just pay it to the models? They're hurt. And doesn't the legislature do this? Doesn't the legislature decide where money goes? And doesn't a court just pay claimants, right? And that was his beef. And so the American Law Institute, you might have heard about that. It's a group of scholars that get together and try to have uniform laws, and then different states adopt them. You might have heard about that. In 2008, they just said, let's have a simple solution. If you can't find all the plaintiffs, if the money's not too small, just pay it to the ones you could find. And you know, the argument against that is that they might be overpaid. In the model case, the fashion model case, they would have received multiples of what they're really hurt. And so that gets us to the next possibility: give it back to the defendant. And you know, we're trial lawyers. We represent plaintiffs, but let's do like Atticus Finch said. Let's walk a little bit in their shoes, and let's just think about this. Now, when you're a defendant, you pay money because someone's hurt, right? You pay the person who's hurt. If the money doesn't get to the person who's hurt, why should you have to pay it? So let me see a show of hands. In that circumstance, how many people say the defendant should pay? How many say the defendant should not pay? Yeah, that's what I thought. I mean, that's kind of logical, isn't it? And you know, you've probably heard about procedural due process in here. That means that there's some rules of law, and you're only responsible if certain elements of a claim are proved. I think the lawyer before me talked about that in a wreck case. And so I think procedural due process would say you should only pay some money if someone's hurt, and pay it to the person who is hurt. And so that's the defendant's beef. And you know, the defendant would say, damage awards are not made in the air. If you can't find the claimant, I mean, how am I responsible? Doesn't the money remain my money unless you find the claimant? And so the defendant could say this: if you make me pay anyway, if you can't find the claimant, isn't that like a fine or a penalty? You know, like if you run a stop sign, you pay $30. And guess who does fines or penalties? Legislatures. So why isn't that just illegal? That's the defendant's point of view. And you know, frankly, I don't know the answer to that. So, you know, we need to keep that in mind. Now, one state, West Virginia, my goodness. It has a case, West Virginia v. Pfizer, and it just suggests, well, if you have a surplus, just give it to the state. So the state of West Virginia had a settlement in a case involving, I think, tetracycline, a pharmaceutical drug. And the settlement read so that if you didn't file your claim in 90 days as a claimant, the excess money went to the Attorney General. And he used it for drug abuse programs, community health clinics. But I mean, why is his decision any better than that of a claimant, right? It still sounds like people usurping power and stealing your money, doesn't it? So I just don't know if any of those are good answers. So I've got a couple radical answers, just like I had with medical monitoring, okay? So the first radical answer is something called fluid recovery, and it's in your handout materials. And it was really attempted in a yellow cab case, and just see how exquisite a remedy you think this is. So you had a bunch of cabs, okay? They're found in the settlement to have overcharged the people, you know, paying for cab service. But the money was too small, and how are you going to find the people that use your cab? They pay you cash. In fact, they might be embarrassed in some of the places you took them, right? They're not going to come forward because they told their wife, and I'm just kidding. But so you have that issue. And so, you know, what do you do? And so the yellow cab case, the plaintiff lawyers had a great idea. Let's just reduce cab fares going forward, right? And they said, well, you just assume that people are going to use the cabs again. I mean, wouldn't that kind of even out? And so that's this fluid recovery idea. You sort of figure out how you could fix it going forward. But you know, it was rejected with some pretty incredible language, actually. This is what the court said. It said, even if Rule 23, which is the class action rule we talked about, the Book of the Month Club rule, could be read so as to permit any such fantastic procedure, the courts would have to reject it as an unconstitutional violation of the requirement of due process of law. But isn't cypre a violation of due process of law because you took my money? And at least fluid recovery sort of approximated paying the claimants, right? Well, fortunately, over time, this idea has begun to get some sea legs on it. And so the fluid recovery idea was actually carried out in a case called Eisen v. Carlisle. And it's so similar to the cab case. So what happened here is you had a bunch of stock traders that deal in odd lot shares. I think that's less than 100 a trade. I guess we have some brokers in here. And the damage was only $70 a head, so it wasn't practical to pay it. And so, well, the settlement was, we'll just reduce the brokerage fees they had to pay going forward, and the defendant will pay it back that way. And that was accepted. And so that way, not completely, because some people might have stopped trading, right? But by and large, the remedy got to the class. At least that's the theory. And so a lot of times, there's a case that talks about this. It's called the Democratic Central Committee. This fluid recovery idea is effective if you have people that are buying a consumer good over and over again. So, for example, if Heinz overcharged for ketchup, we just could have a discount going forward or something like that. In Agent Orange, it was adopted because there's post-traumatic stress disorder counseling for the claimants, and it's pretty much everybody in the class was eligible, that sort of thing. Now, here's a more radical solution. I put to you, this is the mindset of the Supreme Court right now, because it's, I think, it's pretty much 4 Republican, 4 Democrat, and 1 kind of neutral Kennedy, Alan. So there's quite a few folks up there that take a hard look at spending defendants' money for plaintiffs you can't find. So one result may be that if you can't find the claimants, the court's not going to let you have a class action. And so the case that talks about this came out in November 2013, and Chief Justice Roberts wrote the opinion. It's called the Facebook Beacon case. And see what you think about this case. I think there's clearly wrongdoing. I guess we're all on Facebook, right? Anybody not on Facebook? Wow, okay. Got a few dinosaurs. So what happened, they had this beacon service. So like if you had a participating store and I were to buy my wife a ring as a surprise, well, the store would tell my 700 friends, including my wife, so much for a surprise. And that's the facts of the case. Pretty good case, isn't it? Pissed the guy off. So he sued for the class, for all 300 million people. 300 million people. So the settlement was for $10 million or 30 cents each. Okay? You can't pay that, can you? And so what happened is this settlement was developed by Facebook and the plaintiff lawyer. They said, we're going to create this charity. It's going to hold $6 million of the $10 million, or maybe $7 million, and it's going to protect consumer rights, and the lawyer gets a $3 million fee. No money directly to the class. So this is what Judge Roberts said. The court, he decided not to take the case because the facts were not as deep as he wanted, but this is what he says here. He says, granting review of this case might not have afforded the court an opportunity to address more fundamental concerns surrounding the use of such remedies in class action litigation, including when, if ever, such relief should be considered, how to assess its fairness as a general matter, whether new entities may be established as part of such relief, for example, this charity they just designed, how existing charities should be selected, what the respective roles of the judge and the parties are in shaping the remedy and choosing the people to get the money, how closely the goals of any enlisted organization must correspond to the interests of the class, and so on. And this is what he says. He says, this court has not previously addressed any of these issues. And so that is out there right now. The Supreme Court is waiting to see what we're going to do with this issue. And so I think we need to really be frank about this, and because, the theory of law is to protect victims, right? The purpose of law is to protect the weak. If we don't have a class action remedy, many harms will not be rectified because the money per claimant is too small. Lawyers won't take individual cases that are just worth $100, but they will if you have bunches of people. And so right now, I think our class actions are in jeopardy unless we look at this. And so we ought to think up a rule. So I've tried to think up a rule, okay? And what I usually do with People's Law School, I talk about something, then I write it up. I give it to Mass Torts Made Perfect in Vegas. I take my wife to a few shows, beef it up, then I make it into a law review article. So that's where this one's headed. Okay? So I think the first thing we ought to do is when you bring a class to a court, the court ought to decide right then what's going to happen to excess money. And that's not asked. You bring a case, they have what's called a class certification hearing, and the judge says, well, okay, these class members, how are you hurt? Are you typical of everybody's hurt? How many people are there? Defendant, do you have any challenges? He didn't say, can you find everybody? Are you going to get the money to the victim? Aren't those legitimate concerns if you represent the victim? Isn't that more important than a charity? I mean, I'm not against charity. I give a lot of money to charities. I'm sure a lot of us do. But isn't that the purpose of the law, is to pay people that are hurt?
And isn't there a statute of limitations on that? When to make a claim?
Well, there is, but it varies with the type of claim. But I think what should happen then at the class certification stage, if you don't have a good answer for that, maybe that shouldn't be a class. And if you do that, then Judge Roberts will never get a chance to torpedo class actions. Yes, sir.
Yeah, it just occurs to me, what's the reason why it was changed to start with, and can it not be changed back? Or?
Yeah, and again, the reason why it was changed is in 1966, the fundamental rules of class actions were changed. In 1966, the Supreme Court approved new rules which said that to have a class action go forward, you don't have to identify all the class members yet.
But with regard to this, it's not working.
That's exactly right. And so that's what we're talking about, is how to fix this.
But why can't the law be changed or be recognized and dealt with?
You're right, and that's what I'm going to get into now. And so I think the first change, we're asking for change, should be at the class certification stage. That is, what that means is when you decide if you have a class action or not, the judge ought to be satisfied that the vast majority of the money should get to the claimants. If it doesn't, I think you have a problem. And by that I mean, say, 70% or more should get to the claimants. Ideally, 85%. Yes, sir?
What happens to unclaimed tax refunds?
They usually go back to the defendant. Go back to the state.
Okay.
And so usually, wouldn't that be the logic of unclaimed money in a class action going back to the defendant? I mean, that's one bucket. And if you get past a class certification hurdle like that, then you know going forward that the vast majority of the money in the class action, if it works, are going to go to the claimants. So that eliminates a major problem.
What body made this rule to start with? Is this an Alabama type thing?
No, it's a federal thing. The United States Supreme Court.
What body did this?
Well, it's throughout the country, but it was begun by the U.S. Supreme Court approving a new rule in 1966. Yeah. Okay. So I think that's one good safeguard. Wouldn't you agree that before you have a class action, let's make sure that most of the money gets to the plaintiffs? That sounds logical, right? Okay. And then...
Could they not devise a different system of class action so that you had a class action for the accountable people? You could return the money to the people who were damaged, and the other class of class action would be the situation where the money could not be returned to the people who were damaged, but the company who, or the plaintiff who created the problem would not have benefited by the situation existing. Could that not be determined before the situation, or before the case went to court?
I agree with you, but yeah, the idea again is let's try to identify the plaintiffs, and you know I'm saying if you ought to look at it before you bring your case. I agree with you, but you should certainly look at it when the judge is deciding whether it's a class action. I think we should see if we can get the money to the plaintiff. I mean, isn't that the theory of a class action, to represent the class? So I agree with you, but there's still going to be...
What I'm saying,
yeah, go ahead.
Is can you not put another category in there where the money, in a case where the money can't go to the people who were damaged?
All right.
The plaintiff or the person who set up the situation, who caused the situation initially, made an excessive profit by his inactions or by his actions, however you want to put it, and it not be set up so that that money cannot be taken back from that company so that it's not making a profit on these people and put into a category, so that you've got two different categories of class action. You know, well, not two of class action, but you have class action and a different sort of case here that could not be formed into a class action but could still follow the same guidelines.
Well, let me see if I can restate your question, because I'm trying to follow what you're telling me. So if you can find the claimants, pay them.
Right.
All right. For the extra money, You use that to punish the defendant somehow by reduced profits or excess taxes or something like that?
Well, what I'm saying is if you can't return the money to the people who were damaged,
Right?
okay, then the money is in a lump sum over here going somewhere.
That's right.
Okay, so what if we before we take those cases into court,
Yeah.
we have a category for a situation where the money can't be returned to the plaintiff? We don't want to drop the case, or
Right.
to the plaintiff, right? We don't want to drop the case, and if we drop the case, the defendant has an excess amount of money that he's made for no good reason.
Right.
Okay? Can we not segregate that from the other type of class action suit before it ever goes to court, and determine, therefore, before the situation where the money's going to go?
I don't think you can for this reason. I think until you work through a case, you don't know how many people you can find or not. For example, in the Jefferson County case, I was amazed that we found 85%. I thought we'd find 70. But you know, a lot of states have a statute about excess funds, and they might have a certain proportion go to this charity, a certain proportion to that charity. So that's a possibility. But I think however you slice it, as long as you have a Book of the Month Club class action, there's going to be some money you cannot get to the plaintiffs. Yes, sir.
Kind of along his method.
Okay.
As you set up the notification
Right.
and you get the respondents,
Right.
could there be a poll, an agreed upon series of actions for unclaimed funds? And I know that the knee jerk would be, well, I want it all, you know,
Right.
the plaintiffs, but I mean, no. I would say that there would be some you know, I've seen these cars, they're quite large with little print,
Right.
or a magnifying
Yeah.
glass. You could go over those courses of action, and then the respondents would select where that excess money goes. Then the folks who were damaged would determine that course of action.
Yeah, that's a good segue because we did some of that in the occupation tax case. We had a fairness hearing and the people could come and talk about it. Yes, sir.
Sir, you're receiving a lot of possibilities as answers.
Sure.
Is there somewhere or somehow that you could tell the viewing audience
Yeah.
how they could submit their suggestions?
Yeah, sure. Just email me. And I think my email's on the cover of this, right? Yeah.
Could you say your email?
Sure. It's ESCROWAGEN. That's such an old email. We didn't have enough letters at the time. It was to be escrow agent, but it's escrow agent without the T. I'm dating myself, I guess, Alan, at AOL.com. But let me march through my idea, okay? So we're going to have this excess money as long as we have Book of the Month Club settlements. I think we all agree. And we all agree it's a difficult issue, right? And there's no good answer. And so I think what you would do at the class certification stage, you need to make sure that the substantial majority of the money is going to get to the class members if the case works. And that way, you know, going forward, it's not a false class action, right? And that would be a huge reform. And then I think when you have an excess money, then I think the judge needs to carefully go through some steps. And here's some suggested steps. If the money the claimant's got already does not fully compensate them, and a lot of times it doesn't because it's a compromise, right? Say you're hurt X and you're paid 1/2 X. Well, if you get a dividend and you get another fourth of X, you'd have 3/4 of an X. You don't get all X anyway. And at least we're paying the claimants. And we're not giving them a windfall, right? Because they're still not getting everything they're hurt. So that ought to be, just like the American Law Institute said, that ought to be the fundamental rule for excess. Get more to the claimants that appeared, as long as it's not a windfall. Does anybody disagree with that? That sounds pretty basic, doesn't it? And then I think the next thing you should do is once that step is taken, let's say we pay them up to X. Say they're hurt X and we pay them their full X. Then I think you ought to think about this defendant issue, right? You know, does it make sense to pay the defendant? Does it make sense to give it to the state? Or maybe have this fluid recovery. You know, with a cab fare case, maybe reduce the cab fares out there for everybody. And I think after that, if none of that works, then I think we ought to get to this point about charities. And so this brings me full circle back to the Jefferson County case. And so I think with the charities, I think we need to have it democratic to the extent we can, and I think that's what that gentleman was talking about. And I think the charities should, the use or the purposes of the charities maybe should approximate what the case was about, or at least serve the same people where the class where they're located, say where they live. So what we did in the Jefferson County occupation tax case, I think I said we had $2.5 million. We first looked at whether we could pay it out to the people. That was $7 a head. It cost maybe $5 a person. So you can see that ain't going to work, okay? So we jumped through that hurdle. That's just not going to work. And so then we thought, you know, we might do is, how about a sales tax holiday? It's a tax case, right? And they're in Jefferson County, have a sales tax holiday, and maybe that would approximate it. The problem is, though, that the legislature has to approve sales tax holidays. So we knew that would never happen. And so that made it not viable. So what we did then is we noticed the class of a hearing. And we sent out a request for proposals to the charities. And so we got a fair number of charities, about 24, that submitted a proposal. We had a fairness hearing. Any class member that wanted to participate was invited to come. We interviewed all the charities. And we asked them in the request for proposals, the written submission, the interviews, are you going to serve Jefferson County? Because that's where the refund case was. And if so, what are the purposes? And we try to make sure they don't overlap. But other than that, we pretty much paid all the charities ratably. You know, if they asked for $5 million and their ratable share of the whole pie that was requested is $1.5 million, that's what they got. And so that was the basic solution. And that's not a perfect remedy, but at least, like this gentleman suggests, that the class was told about it before it happened. If you wanted to come, you could. We first looked at paying the money to the class members themselves. We didn't have to consider paying the defendant because Jefferson County is in bankruptcy, and they told me they didn't want it. So that was a big advantage. But that hurdle should be looked at normally, I'd submit to you. But there's going to be some changes down the road, as you know, as the preacher says, change is going to come. One thing you're going to see because of Judge Roberts' decision in November, I think in every class action settlement with Cypre, there's going to be professional objector lawyers challenging it as being legislative, as being beyond what judges do. And I put to you that the only way to save class actions is this remedy we've talked about. And the biggest downside is this: if we don't get our house in order in class actions, it could be that the Book of the Month Club approach will be voided, and then there won't be class actions.
Just had a question. I see a lot of these class action suits on TV, you know, the commercials, they say, you know, call this number or whatever. Are those real, legitimate class action notices?
I think by and large they are. I think that lawyers pretty much have to advertise now to survive. And the reason is just the way our world works now. I guess we have a lot of friends just on media. It reminds you know, the Great Gatsby, like one person showed up to his funeral. You ever wonder about how many Facebook friends would be there? You know, so it's changed, you know, right? So it's a virtual world, I think. And I think that's why people advertise so much. Yes, ma'am.
You know, sometimes I would think that you can't find the people in the class action lawsuit because they don't believe that's the best remedy of a way to solve the problem.
It's true.
So like, we get the little card in the mail that says the blender is broken and file the lawsuit.
Yeah.
So we're ruining companies because lawyers want to make money. And then the lawyer's getting this money that doesn't even go to people because you're saying, oh, it's only $7 a head. So the lawyer's going to get $30 million, but we can't give it to the person. I mean, this is sad.
Could you restate that?
Yeah, I think that the basic point is if you have a class action that doesn't get the recovery to the people, it's sad. And there's fees involved. And, you know, one reform has been suggested. I didn't mention this one because this one's pretty radical. Don't pay a legal fee on the Cypre part.
Right.
Wouldn't that incent a lawyer to represent his client?
Nobody would do it, would they?
I don't know. I don't know. For example, in the Jefferson County case, we paid 85%, and we made sure that not all the fee was paid until we were done. That's done a lot now in class action settlements. You hold back some of the fee. Now, I've never seen it conditioned on the part that's Cypre or not, but it does have some appeal to it, you know, based upon what you said. I mean, why pay a lawyer a fee if he doesn't collect money for his client? That's the logic. Yes, sir.
What's to stop the lawyer when you got money left over from like the oil spill case? off the coast. And they haven't distributed all that money, and they're passing money to people that have businesses off of the interstate 400 miles away. What's to stop the lawyer from just doing more advertising, trying to disperse the entire sum instead of 70%?
Well, again, I think you have to look to the judicial system. The judicial system regulates not just what claimants are paid, but what lawyers are paid. And I found that by and large, that's in the federal system. The federal system is a pretty good system. For one thing, the judges are appointed for life, and all they just account to their God and the rules. And by and large, I think it's run very well. Now, lawyers are advocates, and sometimes lawyers are flamboyant, but I think in the end, I think the system works pretty well. Yes, sir.
What was the case about in the 66 you said that caused this reversal? I mean, can you tell us a little bit about the specific case?
It wasn't a case. The question was, what case in 66 caused the reversal? It wasn't a case. It was just a rewrite of the class action rules. And just the logic of, we have cases with a lot of people and you can't find them all, so let's bring the case. So it wasn't really a case. But what happened is it led to this problem that was unforeseen of having excess settlement funds and trying to figure out what to do with them. Yes, ma'am.
I have a question about where the money is. As far as once a decision's been made and you have this defendant that has to pay, it takes time for that to get to the people that deserve it.
True.
So where is the money, and is it making any money, or is it in a holding tank? What's happening, and if it is making money,
Yeah.
where is the money that it's making going?
Okay. Typically, the money goes into what's called a designated settlement fund. That's a fancy term. Even more fancy, I could say it's a 468B entity under the Internal Revenue Code. All that means is it's paid into a bucket, okay? A settlement fund is its own taxpayer. It holds the money. It used to be that settlement funds made a lot of money when treasurers would pay money. In fact, a lot of times administrative expenses, for example, fees that I'm paid, could come out of the interest, and there'd be interest left. Now, that's no longer true with treasuries, and you almost always just put it in treasuries or money markets of treasuries because you have to keep it safe. It belongs to other people, right? And so really now interest on settlement funds is very, very small, and in fact some banks now charge you just for holding your treasuries. And so what happens is you hold it in that settlement fund, and then the judge with the claims administrator usually designs what's called a payment matrix. How are you going to pay the people? And you just draw from that fund and pay it out. So that's where it is. It's usually in a bank. It's a separate taxpayer, a separate tax ID number. It does its own income tax returns, and it's audited usually. Okay. Now, you got another question?
It's a side question. If a case, a federal case, like under the ADA, for instance, is declared do not publish, and it goes all the way to the U.S. Supreme Court, and all of a sudden it's on the internet, how can that happen?
I don't know, but it's certainly a burning topic in our society now. Just secrecy and yeah, everything's on the internet as best I can tell. Yes, sir.
Yeah, on all these class action suits, I was wondering if a defendant has ever has mounted a legal challenge against paying funds that that didn't go to the claimants.
Yes, that's what that Facebook case is about. And what happened? Facebook was favoring it, but some other groups challenged it. Some right-wing groups, and over the years, defendants have challenged it. And I think it's got to evolve to survive. Yes, sir.
Speculate, if the Supreme Court does away with the Book of the North Club, what would take its place?
I don't think anything can. Because, like I was saying earlier, you have so many cases. For example, in the occupation tax case, the average person was owed $100 in refunds. You can't have individual lawsuits. In fact, the filing fee in Jefferson County is $120. Do the math. And so it just wouldn't happen. So I think you deprive people of their rights. And so I think that's why, as lawyers, we need to clean up the remedy to help it survive. Okay.
I have this observation that maybe it would be like a football game with no umpires, or it would be like we plaintiffs' lawyers said, there are no rules, just let the big dog eat. If Goldman Sachs or whoever they
Yeah,
are
true.
want to just rape and pillage, so be it. They know they don't. I mean, I saw this movie called House of Lies on TV the other night for the first time.
Yeah.
And so I watched it again because it was on right after that. And I thought to myself, these are the type of, basic robber bandits that are in our society that do whatever they want because there is no remedy. Now, if there's no remedy because nobody can put their fingers on it or attach it, so be it. It will be pre-1966.
It'd be a shame. I think it really would be.
Well, it wouldn't be a shame for the Rockefellers or the
No.
Vanderbilts or whoever it was that took advantage years ago.
Yeah, I think there will always be class actions because I think the toxin has alarmed everybody now, and I think we just need to get it cleaned up. And this happens. The law evolves, goes back and forth, and we need to have class actions because a lot of you may be hurt in a way that you can't recover in any other way.
And I also observed that if it passed in 1966, that would have been in the Kennedy and Johnson administration years, and then we flow back to Richard Nixon and the Bush years.
True.
And the pendulum swings, and we all of us Americans try to stay in the middle somewhere.
Very true.
And what's the answer? Who knows? I think it's for people like you to stay up on top of it because the rest of us in the law class weren't smart enough to even think in these terms.
Yeah, sometimes I'm accused of thinking.
Okay, one more question.
Yes, ma'am.
The people in West Virginia that have been damaged from the spill of the toxic
Yes, ma'am.
coal, whatever it is in the water.
Yeah, Freedom Industries. I was meeting with some lawyers about that in Charleston, West Virginia last week. I feel kind of guilty. I dodged Snowmageddon here. I was in West Virginia. It was 15 below, but the roads were clear. But, there's been 23 class actions brought over that. 23. And they mostly overlap. Freedom Industries, you probably heard, has gone into Chapter 11. And so a lot of times the best defense to a lawsuit is no money. And so I'm afraid we had, 300,000 victims. That's a lot of bottled water. Just the use of water and having water serve your house. I think one of the plaintiff lawyers was telling me there, it's valued at like $40 a day by the World Health Organization. So if you just did the $40 times 3 weeks times 300,000 people, what's the old term? That's some real money. But it could be that they'll never recover that. And so again, I mean, maybe it just relates back to you should require anybody that deals with the water system to be better insured. I think Freedom Industries just has a few $1 million in insurance coverage, and it's in Chapter 11. And that happens.
Couldn't you go after the EPA since they hadn't been there in 20 years to do an inspection of all that business?
Well, pretty much they have sovereign immunity. It's kind of hard to sue the government.
Ed, thank you so much.
Pleasure. Pleasure. Thanks.
Mr. Price and Mr. Flowers and I were talking here today about a real hot topic, and that is what we're seeing on our highways with these lawyers that are advertising on these billboards, making fools of lawyers. That's what I say. And it's an opinion. The people that are doing it are lawyers and my friends, but I've got a real strong opinion about it. I have read, and all the studies show that the number one thing that people hate lawyers for and have the bad rap for is those foolish advertisements. And it embarrasses me every day. I know maybe you have. I'm sure, Phil, you've seen it a bunch where in my negotiations with the other side, my own clients will say, well, if we can't settle it right now, I'll just get a wreck and get a check or something.
533?
Yes. That's it.
I haven't seen any of them personally. I'm just kidding. When I first started practicing law, was right when they changed the rule to allow lawyer advertising. But it seems to have evolved. I mean, lawyers have a bad pitch anyway. We have a thing to overcome in terms of perception by the public. But I think advertising can be done in a responsible and ethical way. But it seems that the advertisements have gone way over to the edge, like any other thing, if you will, business. And my one comment would be it's obviously working to some extent, because the number of dollars that you see spent, they've got to be getting cases in and turning it over and buying more advertising.
You know, and in our field, probably what we see more than anything else, and what Phil and I do is Phil and I do DUI defense, and it's criminal issues. And we actually do see that too in our field, and we hear about that also from clients. From what happens is you know, if a person gets arrested, then somebody is, you know, going through courthouse files and pulling up their personal information and sending them, you know, basically sending, they get a, you know, a virtual plethora of flyers. And, you know, in those situations, I think it's really, you know, it can be incredibly tacky, because somebody's, you know, mother may not know about it, you know, somebody's family member. It's going to some address that's on a driver's license. You know, a spouse, you know, an ex-spouse, you know, a soon-to-be ex-spouse. I mean, so there's all sorts of issues that come in there, and I think I probably hear about it more along those lines than anything else.
Call that jail mail, or that's the name that's, they get the public records from each of the jail facilities, and then the lawyers will, and they said that this is ethical. I don't agree with it, but then that's your target market, and some lawyers get that target market, send a letter to their last known address on file with the courthouse, and send them a letter saying, hey, I'm out here, please come and hire me. I heard you got arrested.
What they're doing, if you get arrested, you get a letter in your home mailbox, and it opens up and says, please call us for your defense. We're real good lawyers. Yeah, I think it stinks, and like you say, your mother gets a hold of it or somebody else. And then when you see this on the highway, that just makes people look so foolish. What our discussions are with us plaintiff trial lawyers, the car wreck lawyers, which I do, is that we're seeing from the insurance companies, they're laughing at them because they know that those people don't try cases. They are not real trial lawyers. And what they're doing is they're settling. You got a $100,000 case, they'll settle it today for $60,000 because they know if they refer it on to real lawyers who try the case, they won't get as much money. That's what we're seeing. And we're seeing them discounting the cases. And as a result, when I have a legitimate case, what I'm seeing is that they're not paying as much, because it's like when the real estate market goes down and your neighbor sells his house for much less than it's supposed to. You do it for about a year or so, and that's the appraised value of the cases. And that's what's happening, we're seeing, regarding these whatever's going on the highway. And it embarrasses me. And I think of Atticus Finch. When I was coming along, I think of Atticus Finch. You know, when, remember the old black man standing in the balcony, and he says, Gregory Peck is packing up his briefcase and walking out of the courtroom, and the only people are left in the balcony, and the old man stands up, Tom's father, and he says, stand up, Scout, your daddy's passing. Remember that part of the movie? At the very end, he'd lost the case, he'd done everything, and the little boy was convicted anyway. But the old man, his father, said, stand up, girl, your daddy's passing.
That's the best form of advertising, is results.